get to the same outcome.
Absolutely.
So this is one, a kind of justice that you might get from if you have the structured data.
Well,
the consistency?
Yeah, the consistency.
Okay.
So that actually is a huge point, because when I was at eBay and PayPal, we resolved 60 million disputes a year. And people would say, well, what is the objective criteria that you're using? Now, we did have some objective criteria, but what people really craved was consistency. Right. They wanted to know that if the same situation arose multiple times, we would get the same outcome. And before, when it was a human-powered process, I had someone who was a complainer about eBay and the randomness of the decisions that were being generated. They sent me a picture of users coming up to a desk, and there was a person at the desk, and it said, PayPal customer service. And the person said, yes, our expert evaluators are deciding your case now. And the door was cracked open, and you could see behind them, it was a bunch of monkeys with darts, throwing them in balloons, because the users felt like we're rolling the dice. And actually, there are aspects of the justice system in the United States. I mean, you go to jury trial, there's a lot of studies that show, you don't know what's going to come out of there. Sometimes it does feel like you're kind of rolling the dice a little bit. So if people crave consistency, another thing we found at eBay was people would rather lose their dispute quickly than win their dispute and have it take a long period of time. So there's an element of the perfect is the enemy of the good. If you can create consistent outcomes, and then people know, if I do this, this is the outcome I'm going to get if I go to a resolution process, you may achieve your objective. And then it's not necessarily about is the outcome just, so much is the outcome consistent. And I don't think that's something we think about in the court context enough. Consistency as opposed to justice on a case-by-case basis.
Especially as you have such high levels of compromise and settlement in the courts. And
Absolutely.
then, A, you don't know it's consistent, B, it's subject to a lot of discretion.
Well, one of the things that we found is a lot of these big law firms, they have huge data sets themselves, and they have a pretty good idea about what a consistent outcome should be. But if you look at public defenders in the United States, they're heavily under-resourced, and they often don't know what a fair outcome is. So they're getting into what we consider an asymmetrical negotiation, where one side is empowered with lots of contextual information because they have a lot of resources behind them, and the other doesn't have a lot of contextual information, which means the high information party has an advantage in those negotiations. So there's a lot of talk about, could we use AI, or maybe data science, to aggregate a lot of this information and provide it to public defenders so that they would be more on an equal playing field. So we can revisit that too. Yes, please.
I think with the question of consistency, one of the problems is that, again, going back to the point that Neil was making, what is perceived as consistent sort of assume that there is similarity, and this is a normative decision. And I think that one of the questions is what it is that we are losing in shifting to a system that would provide us with more consistency, but will not allow us to develop the law. So you talked before about one of the downsides of settlement that is, is making the law or the normative decision confidential. But I think what we're losing from a public perspective is the ability to negotiate the norms and develop them in a publicly transparent way through, social or public institutions that we call court or something else, right?
Absolutely.
And so I think that there is, I think that the problem of similarity in terms of machine learning is actually, there is a Israeli startup I just heard that is not serving judges, but serving lawyers for identifying what would be the similar cases, what would be the relevant precedents for your briefs.
Sure.
Right? And so this is something that, could be used as by systems like that also in court proceedings. But I think that when we look at public welfare, I think that is something that we don't want to do just because we want the judicial system to be more transparent about the normative choice of the
Again, the tension between transparency and confidentiality. You raise a very important point, which is, I think oftentimes, the reason why we're focused on these low dollar value civil cases is because, at least in the United States, we have a huge problem with what they call self-represented litigants. People who have no money, they can't afford representation. the legal system was created with lawyers in mind, people who have had 3 years of legal education, they've taken the bar. These self-represented litigants come into the courts, they have no idea what they're doing. No one is willing to give them any advice, even at the clerk's office or at the legal library, because they don't want to be accused of providing legal services, because then you can get in trouble, you know. I myself, I'm a non-lawyer mediator, so I do not have a JD, but occasionally bar associations will come after me and say, hey, back off, you know, this is unauthorized practice of the law. You can't do that. Now what I found is, once we went to low dollar value cases, civil cases, lawyers don't want those cases because there's no billable hours there. So nobody cares if I'm delivering services to them, even if it's tens of millions of people. But the challenge is the court process, the public resolution process. It has a lot of procedural protections built into it. And a lot of the benefit that comes out of the traditional judicial process, as you note, comes from learning from that case and then evolving the law. But as an individual disputant, if I'm a landlord and a tenant, and I'm responsible for covering my filing costs and covering the cost of participating in that system, it may be that that creates a barrier to entry for me, because I have to pay $1,000 or $2,000 or $3,000 to the lawyer to try and get back my $600 for my security deposit. So what we're finding in the United States is courts at all levels are trying to privatize a lot of these cases. They're trying to take them out of the public justice process because that process is just too costly on a per case basis. I work with courts all the time and I say, how much do you pay in your costs per case? And they have no idea. They don't know what the cost is. I mean, they know they employ people and they think about cases on a per case basis. They have a process and they want to provide equal protection under the law, so every case that comes in gets equal protection. But they'll spend $10,000 in costs, in court clerks and document management and all of that, to resolve a $500 case, which no one in the private sector would do. There's no economic rationale for that. And then the case settles, so it doesn't even benefit the development of the law. So what I often think about in online dispute resolution, again, are we making the perfect the enemy of the good? We know that if you have a lot of money, the court system can work great, and there are a lot of procedural protections, and it can deliver fair outcomes. But if we have a process that's designed for $1 million case, and you try and apply that at scale to $1,000 cases, it simply doesn't work. And not to put too fine a point on it, the justice system for low-income litigants, self-represented litigants, is broken in the United States. The outcomes that people get are terrible. And legal service bureaus that are tasked with providing legal services to these people are hopelessly under-resourced. So people say to me, you're building a rough justice process. You're building, at eBay, for instance, we had a bunch of $100 cases. None of those cases are ever going to go to court. So people say to me, well, you know, the court has this procedural protection and this procedural protection and this transparency and this precedent-based, you know, but your system doesn't have any of that. I'm like, yeah, but the cost of those benefits makes that process completely inaccessible to people that have the kinds of disputes like I'm wrestling with. So can we build an expedited process using these mechanisms that lowers the cost so it would work for a $50 case? If you go to Brazil, it's very interesting. The Brazilian judiciary is a fascinating process because they're very pro-consumer. But when you fly into the airport in Sao Paulo or Rio, they have a sign over the baggage claim. And it says in Portuguese, I'm going to have to translate it for me, although I see Portuguese on the wall over there with those fake ads. It says, how was your flight? If you had a problem, why not file a lawsuit? And they actually have a court right there next to the baggage claim. And you can go in and for free, they have a console, a touch screen, and you can say, I had this problem on this flight with this airline, and they file a case for you. You don't need a lawyer, you can just go through the process. And then lawyers start to call you up and say, hey, I saw that you filed this case for this, I'd like to represent you in this case. And the way it works in Brazil is, if you win that case, all of the lawyer's costs are paid for by the business. So there's a backlog of more than 80 million consumer cases in Brazil. And when I say that to judges in the United States, they say, that's insane. You know, how can you possibly, because we have backlogs already in the United States, how can you possibly just allow people to file lawsuits for free? And I'm saying that is the future of the justice system. We need to lower the bar for people to file cases much, much lower. We have to leverage technology in order to be able to develop resolutions for those cases at scale. And we need to get the cost down so low that we're not spending $5,000 on resolving a $500 case. And that's what's so hard, I think, sometimes for the judiciary to wrap their brain around, because in the United States, a lot of people in the courts and in the bar associations, they think access to justice means access to lawyers. And in the ODR space, we're saying, no, we want to reshape that. access to justice does not mean access to lawyers. It means access to fast and fair resolutions, and we can deliver that with technology. Now, the lawyers don't necessarily like that argument, but okay. So let me just get through a couple more slides. I want to show you an actual example. How am I doing on time? Okay. How often do we go? I don't want to keep people here all night. It's the end of the semester.
Well, we'd like to see an example.
All right, let's get some examples. I'm not going to talk about the benefits and challenges because I will address this in a minute. A big book, I don't know if you know Richard Susskind.
He actually spoke at a few years ago.
Yeah.
At one of these?
No, a few years ago.
Okay, all right. Well, Richard is obviously, he's the chief IT advisor to the Lord Chief Justice in the UK. He's written a lot of books about online dispute resolution, about the future of justice. He wrote a book called The End of Lawyers, but it was the end of lawyers question mark, not the end of lawyers exclamation point.
He wants to sell.
He wants to sell, that's right. He knows his market. But he does talk a lot in his new book, which just came out a couple weeks ago, about AI and the courts. And his last book was on the future of the professions and about how AI is transforming expertise. So traditional expertise-based professions like lawyers, doctors are being replaced by AI. So we can talk about this, but these are the 5 key questions that he says we have to ask about AI when we deploy it within the justice system. Okay, so let me just talk about, in ODR, where do we see the opportunities for integrating AI, and machine learning mainly in particular. So I work at Tyler. Tyler is the #1 provider of court technology in the United States. 50% of U.S. citizens live in a county where Tyler runs some aspect of the courts. That may be court case management, that may be e-filing, and that may be ODR. So Tyler is really the company that is tasked with building the future of e-justice, I guess, in the U.S. So Tyler, we've talked about, there are 2 components of ODR where we think AI can fit in. One is in diagnosis, which is, again, helping people figure out what's the nature of their problem, putting them into an appropriate resolution path, asking them questions in guided interviews, and then helping them create documents, maybe even scanning a document, understanding what is in that document, and then putting it in structured text so they can file a case. And then we talked about research as well. There's a lot of companies that are looking at legal research and figuring out how can we use AI. And the other area is facilitating the conversation. So that means classifying cases, creating a taxonomy where we can sort cases into appropriate categories and create structured data out of it, structuring the negotiation between parties. So as I talked about with blind bidding, evaluating evidence, comparing incoming cases with past cases. So I want to show you some examples of kind of how this is happening in practice now. This is something that actually they have in Los Angeles, and it's sort of this is an older technology. I think lots of people use this at PayPal. We had this too, this kind of virtual avatar, and you can answer questions, and it will put you into appropriate paths. This is not machine learning based, although they are classifying lots of their cases to figure out what information do they need to share. So this is Gina, the virtual traffic assistant. This is another company. I showed you their little robot before. It's called Renterventions. And it's a chat-based interface that uses natural language processing to help people with their eviction cases, particularly in Chicago. So what I want to talk to you about, because this is what we're focused on at Tyler, is the use of natural language processing in these kind of conversational interfaces. And this is a very targeted application in one geography with one particular case type. So natural language processing is AI, but actually it's now being delivered as a service through most of the big ISPs. So you can go to Google, if you host on Google or AWS, they can deliver natural language processing as a service. And they're improving it on the back end by constantly training their algorithms to interpret free text. So this is what we've put together. We actually call it the resolution tool. And Tyler is now building this for sale to individual courts in the US. It's not yet live, it's still in development. But what we found is the vast majority of these self-represented litigants, these SRLs, they access the internet through mobile devices. So if you give them a laptop-based experience, it's too much information for them and their usage of it drops off. But if you give it on mobile devices, actually there's a lot of uptake. So we've created this client, we call her Terry, and when people come in, people just start saying, okay, what kind of legal issue do you have? And we've created a taxonomy of the major dispute types. So divorce, debt, housing. You can click on another interface, it'll give you a big list of buttons, and you can click on a case that's relevant to you. But say you say, I want to get a divorce. And we say, okay, I know this is probably a hard time for you. The good news is I can help to make this, the legal side of this easier. Let me ask you some questions. So then they put you through a structured, guided interview to collect the information they need to put you into an appropriate resolution path. Because obviously, if you're young, you don't have any kids, you have no shared assets, that's actually a relatively simple divorce in most states. But if you are married for a long period of time and you have kids, it's a little bit more complicated. So once we figure out where they're located, we can then say, okay, let me ask you some questions. Do you have any children under the age of 18? We say yes. Okay, since you have a child under 18, you'll need to agree on how to take care of the child. That's something we can help you with. Sometimes instead of free text, we put in yes or no options or pick lists. But essentially, once we gather all this information from the parties about the nature of their problem, we then can create a series of options. We restate to them the information that we've collected so that they can correct anything that we might have gotten wrong in the conversational interface. And then we say, okay, here are some options that are available to you through this process. And we can say, okay, you can work it out directly. You can use the resolution tool, which is an ODR-based tool, which is integrated into this app, to work on the other side and create a parenting plan. You can file a case with the court, and actually all the functionality to do that is also integrated into this app, so it'll help you put your filing together and then e-file it directly with the court. Or we can hook you up with a lawyer, and the lawyer can come online and provide you advice if you need to learn more information about your rights in this particular case. So then we also create a roadmap. We call it a subway map that maps out what we call their justice journey. And then the parties can use this app to track their progress through this particular justice journey and make changes. We track all of the steps that are necessary and then say, okay, this is where you are in the process. And then we track all the timelines. So if they need to fill out a form with the court, Tyler, we do all of that e-filing. So we have a guided process where they can come through and fill out that information, and it'll complete that form and e-file it into the case. We also have visibility into all of the cases that are live with the court. So you can actually see, you get notifications when you have deadlines, when your hearing is coming up, when a document is due, and you get logged back into the same interface, and it'll say, okay, your petition for divorce was served to John Smith on this date, your hearing is up next, this is the name of your case, and then we actually will give them information about where the county court is located, what time they need to show up, and we have a page that tracks their case, everything that's happened in the case, the steps that have occurred, checked off, and then the next item. So we're still trying to integrate this on a county-by-county basis because the United States, the justice system in the United States is very fragmented on a county-by-county basis. But what we're trying to do is create a single point of contact powered by natural language processing that can walk parties through their justice journey from the very beginning when someone says, you know what, I think I need to get a divorce, and they do a Google search and they find this app all the way through the mediation process, the court process, and then the actual final decision from the court. So the question is, could we use conversational interfaces like this? The beauty of a conversational interface is you can also deliver it by voice. So it could be delivered over an Amazon Echo or over an audio capability as well. So I guess the other point that I want to make, and I'm not going to belabor this because I want to get to the discussion, there are a lot of ethical concerns that emerge from the use of these tools. Actually, I really like this book, Weapons of Math Destruction. And then my friend Jan gave me this book, Automating Inequality, too. I think if you have biases that are built into the data, that will also come out when you deploy these mechanisms at scale. So, and the last point that I want to make, and I'm not going to go through all the recommendations of this report in great detail, but there was a European ethical charter for the use of AI in judicial systems, and they came up with a series of principles about how that should govern the integration of artificial intelligence into the courts. And they talk about respecting fundamental rights, non-discrimination. I'm sure many of you heard about Google. They had an image classifier issue where it was AIs and they started to make some terrible recommendations. So this is how we can monitor and evolve some of the information coming out of this machine learning. Quality and security, transparency, impartiality, and fairness, and then ensuring that AI is always under user control. So the computer, essentially, users must be informed actors, knowing essentially what role AI is playing in their cases. So we have an organization we've created in the ODR field called ICODR, the International Council for Online Dispute Resolution, and we are working on ethical principles for machine learning in the ODR context. And we want to certify all of the deployments of these tools for online dispute resolution purposes, and then do ongoing auditing to make sure that they are operating in line with these ethical principles. But this is something that we've seen as ODR has hit scale. It's very important that we have a body that can monitor these deployments, because you can imagine how people might be able to create private ODR mechanisms that leverage machine learning, and actually they're kangaroo courts, and the users don't have the visibility to know that they're actually getting low quality outcomes. So the long and the short of what we've learned in ODR and what we want to apply back to the applications of machine learning is we need to listen very hard to critical voices and give them a seat at the table. We need to make sure that all of these deployments respect the human psychological journey in these processes, as opposed to just automating cases and cranking outcomes. We need to think about humans as partners to machine learning, not obstacles. And we need to have lots of, and we got academics in the room, unbiased empirical research. It can't be based on hunches, and it can't be based purely, the agenda can't be driven by for-profit companies. So what we're seeing in the United States is civil society organizations like the Pew Charitable Trust are paying for researchers to come in and do unbiased empirical research so we can continue to evolve these mechanisms so they work the way that we want them to work. So let's open it up and see. What are your thoughts and reactions? Please.
It was really interesting, your application. But I was wondering how it affects the decisions that are made by those who are guided by that. For example, if I am thinking about divorcing my husband, okay? I mean, if I go to a person,
Sure.
and that person then, starts, a conversation about what drives my, my decision and whatever, I might then decide that I actually don't want to divorce my husband.
Absolutely.
Whether, if you give me the 3 options, it might change my decision. It might affect, the way that I react.
I would
it's
say
not
there's-
necessarily positive.
Yeah, there's no question that the way that this information is presented will affect the way that the recipient feels their options are laid out in front of them. What we found, actually, a colleague of ours, Ayala Sela, has done research about interacting with humans as opposed to interacting with algorithms. And what we're finding is, if you actually look at the preference numbers for parties who are beginning this justice journey, they oftentimes prefer to interact with an algorithm initially. And people are getting very savvy about how they go and evaluate their options. So I've built what we call diagnosis wizards for many different kinds of civil cases, family cases, landlord-tenant cases. We call them litigant portals, in essence, for people who are learning about their rights and learning about the process. And what we found is people often go into these wizards and answer questions a certain way, and the wizard will make a recommendation. And then they'll start over again, and then they'll answer questions a different way, and then see how that changes the recommendation, which you would never do with an attorney. If you went in and they said, okay, tell me about your situation, lay it all out. He says, well, I think you should go to court. Let's start again. Pretend that I didn't tell you any of that. Let me answer the questions a different way. People are now relying on these online sources, these diagnosis wizards, not only to decide where they're going to have dinner, but like who's going to do their heart surgery and what school they're going to live in, and who's going to work with their kid, on autism, or who's going to do their, tummy tuck. It's amazing how much people are now starting to rely on these algorithmic sources of information to get a sense in their head about what their options are. And what Ayala found is that when people negotiate, particularly against these algorithms, they actually trust the algorithms in some respects more than they trust the humans, because they feel like humans can have malevolent intentions and be sneaky with how they portray information. If you go to a diagnosis wizard, that wasn't created for you. You haven't even logged in. They don't know anything about you. So you can go through, and maybe if you don't like that recommendation, you can try another diagnosis wizard and see how those recommendations differ. So I'm not countering the point that you make, which is the way you present this information to disputants will change the way they think about their case. But I guess what I am saying is there are ways that we could do better than the human interface.
I would also say something else. I think Michal is also presenting a barrier, right? So in a sense, a human can be a barrier. And I think we want to ask what types of barriers different types of parties face. And when we talk about divorce, we might be imagining a certain type of divorce, but I think there are, certain echelons in society for whom divorce is like a lifesaver, and they can't even imagine how to go that way and what would be the path. And maybe putting that in the phone is like the only way they can, get out of the situation. So there are risks about things being too easy, but it's also about access. So it's complex.
And I do think the way it's portrayed, this mock-up that you see here, this is just a mock-up. But how we present those options to parties, that's a very important decision juncture, and we need to get a lot of weigh-in from lots of people, the bar associations and the courts and social workers and psychologists. How do we present those options? Because what we often talk about in dispute resolution is the ZOPA, the zone of potential agreement. And I have mediations where one party comes in and says, I'll pay $100, and the other party says, I want $10,000. It's like, oh man, this is going to be a hard negotiation because there's no ZOPA. The circles don't overlap. But where do those expectations come from? Maybe they talk to their cousin who doesn't know anything about this and says, I bet you could get $10,000. So are there ways that we can portray this information? Maybe the fourth party can help to set reasonable expectations and say, look, here are 10,000 cases look just like yours from the last 6 months, and here's a distribution graph of what they are. Yeah, one case did get $10,000, but 90% of these cases were settled for $250 to $850. And that could be important information for the party. I'm sorry, you have a follow-up?
No, yeah. I mean, maybe part of it can be solved through, again, this is an invasion of privacy, of course, and you have all kinds of other problems with it. But if you know something about the person, you can then structure, what your, I mean, because we get signs. I mean, when I walk into a room and there's a lawyer sitting there, the way that I'm dressed, the way that I sit, the way that I talk, send him signs. And here you have a system which, might, you talked about the need to respect human psychology.
Yes.
So I'm just wondering how you respect human psychology when you do AI in this way. So maybe part of it is the data about me.
Absolutely. One of the things that I've actually heard on eBay, we had some of our most successful sellers who were actually disabled. And we had a group called the Disabled Online Users Association, and these guys were making millions of dollars. And they said, I couldn't get a job in a McDonald's, because if I showed up and I was on my cart, and they would say, I can't work with you. Or people wouldn't want to buy from me, because maybe my disability made them uncomfortable. But on eBay, you don't know anything about the other side. You don't know their race, you don't know their ethnicity, you don't know if they have an accent, you don't know if they're disabled. And these people felt that empowered them. So giving someone an option where they might be able to access the justice system without having someone judge them on the basis of their appearance or those things, sometimes that may be empowering at the same time. So because you have more control over what information you share, which you don't get some of those cues. So I think there are many complicated questions that we need to answer in terms of how these new options present themselves. But I think we can agree there's promise here. And were you going to say something?
No, it's just... Oh.
I'm sorry, I waited too long.
Oh, no.
Yes, what were you going to say?
I got actually two questions. So the first one on discrimination, I wondered that all the time. So how do you take care that that doesn't happen? I mean, you said that people should keep control over AI, but that's the point of AI compared to an algorithm. The algorithm is transparent, AI is not. So how can you be sure, are there countermeasures that the system does not discriminate? Because you made that example, and there are a lot of personal information, for example, the part of a city you're living in. Maybe it's the wrong one. Maybe that's why you got a...
That's an excellent point. I know there was a study about one area in the United States where AI, machine learning, is being used at scale is the financial industry. So when you apply for a credit card or when you apply for a loan, they'll look at your data set and then they'll determine how risky is this person. And one of the things that they didn't want these algorithms to factor in is someone's race. So even though they knew that, they wouldn't share it with the algorithm. But then when they deployed the algorithm at scale, they found out the algorithm was so accurate, it pretty much created a proxy based on where someone lived, and then it was using that information in its decision-making process. Apple's just released a new credit card, and there was a big scandal in the US just a month or two ago, where a guy got a notification that said, hey, we'd like to give you the Apple card, you're going to have a $50,000 credit limit. And his wife got the notification and said, hey, we'd like to give you a new Apple card, you're going to have a $10,000 credit limit. Now, they get the exact same financial, same credit score, everything. The only difference is gender, ostensibly. So this was a huge black mark on Apple, and then Apple went in and said, okay, I'm so sorry, this was the algorithm. We didn't go into the algorithm and say, give lower credit ratings to female consumers, but it came up with its own thing. So we're going to now go tell our algorithm, don't look at gender. And we're going to actually change the data set and change how the data is presented to these mechanisms so that they aren't so focused on gender. So that, again, I think is an interesting question.
But we only know if it is discrimination afterwards, when we are...
That's exactly right.
So that's the point, what I mean.
Yeah.
And as you mentioned, Apple also says, okay, that's the algorithm, the AI, then
Yeah,
it's
wash
not
your
us,
hands
so
of it.
we're
Yeah.
not responsible.
It's not our
That's a big problem, isn't it?
Well, again, we were talking before about Google with this image classifier, and there was a scandal in the United States where people would do a search for gorillas, and it would return images of African American people, and because the image, whatever, their image classifier was going in and looking at commonalities, which is horrifying. So that was a huge public relations scandal. So they had to go in and manually, try and review this and train the algorithm. Don't make these connections. So I think it's a question of, we can't just let the algorithms run haywire, even if if they make some of these, and that's kind of what the European principles are talking about. The algorithms have to serve human purposes, so we have to then shape the algorithms based on the outcomes. And if they're generating outcomes that we think are morally indefensible or they are biased, we need to then go back and alter the algorithms to ensure that they don't deliver those results. So that's a tricky question as to how one does that. But
can I follow up on that?
Please.
I know you've got a second question, just following on to this. It might be a silly question, but rather than populating the data set with every case in the entire legal database in America, can't we choose to populate it with only the 10,000 cases which have been vetted as the pinnacle of justice, that we want the algorithm to learn only from these 10,000 or 20,000 cases that have consensus from 99% of jurisprudential scholars, and not just every case?
Well, first of all, it might be a tough question to figure out which of those 10,000 cases are. I can see that being hotly debated. Yeah, but I think that is an excellent point. I mean, again, if we're saying, okay, well, this is the raw data, and the machine learning algorithm is learning these things from that data, we're going to go manipulate the data to affect the outcome.
Yes,
again,
to push it towards justice.
But again, justice. I think, I'm actually a descendant of Oliver Wendell Holmes, who was a famous Supreme Court justice in the United States. And Holmes was famous for saying, I hate justice. I hate the word justice, I hate the concept justice, I hate that people call me Justice Holmes. There was actually a famous time where he had lunch with Learned Hand, who was a younger Supreme Court justice, and as he drove away in his carriage, Learned Hand said, do justice, sir, do justice. And Holmes made them stop the carriage and go back and say, don't ever say that to me again. Because he said, when people talk to me about justice, I know they're not thinking about the law. My job is the law. My job is to interpret the law. I don't know, is it just that, Israel has great hummus and American hummus is terrible? I don't know. Is it just that, it rains on your wedding day and it's sunny on my wedding day? I mean, justice is almost a divine question. It's almost a philosophical concept. So for us to say our objective is justice, how do we change these data sets to ensure that's what we're delivering? I do think that there is an important question if we don't know the process. Like in the dispute resolution space, we vet process. We say, look, before we have any cases going through here, can we look at this process and say, does everybody buy in and say that this is a fair process? People say, yeah, thumbs up. But if we're doing machine learning and we don't understand the process, we have to evaluate it based on outcome. And if there's one thing we know from dispute resolution, truth is in the eye of the beholder. You can have an outcome that one side says is just and the other side says is unjust, and you can debate that endlessly, and there's no objective reality. Where we can say we're going to optimize the system. Now there may be clear cases of bias and injustice that we can say, well, this process delivered that outcome. We need to go and change this process so it will never deliver that outcome again. But I think the notion of us humans coming in and manipulating the data to create the perfect system, I think it opens a Pandora's box that I don't know if we can close. So, yes, please.
This is just a quick point on your last comment. I think it's a very interesting time to study this shift into a world with no oversight over process, just because I think that with the growing distrust of the courts, worldwide, definitely in this country, but I think in other countries too.
All around the world.
I think that the people lack trust, over the process, and so we are reluctant to trust the process, and so we inevitably go to this world where we disagree on the outcome and what justice is, right? Depending on our political views interesting. But I wanted to ask something else. And that has to do with the fourth player, or the fourth party that you mentioned. Because I think that in the systems that you have described, and these come from, commercial parties, I guess. I mean, this is like legal tech is like all over the place. And the question is, where is the profit? Where is the business model? I mean, I look at the divorce app, right? And so if there is something that is profitable in having people engage with it in order to learn more about, to get more data, or to simply, make, have some benefits, from some payments that you generate. There is a bias, that is built into these apps that is non-transparent and is affecting, the process to begin with.
Well,
that we didn't have in courts. The courts are, we can blame courts for many things, probably their own bias, but it's sort of neutral in this way. They don't care if we come to have our disputes, in courts or not.
Yeah, so neutrality is an interesting concept, and in dispute resolution, it's almost like justice. We spend a lot of time talking about neutrality. But I want to make a comment that tries to synthesize the 2 points that you made. I believe somewhere down the road, I say this to my kids. I have 2 kids in college. I said, you know what? I bet your kids are never going to have a driver's license. And I think they are going to be in the era of self-driving cars. And they're going to think back on our era of human-driven cars as hopelessly terrifying and primitive. Like, where if a semi-driver sneezes, they can take out 5 Hyundais. At least in the United States, every day you drive to work and they have traffic reports. And they say, oh, well, we have a fatal accident on the highway. It's like we just take for granted, okay, well, that's part of what it means to drive. And it's not going to happen overnight. Now we have Teslas, that'll drive on the highway, and we have cars that will park themselves. Slowly but surely, the cars are going to get smarter and the processes are going to get better. And again, it's based on outcomes. We're going to objectively be able to say it's safer for the machine to drive the car than it is for us to drive the car. And eventually, we're just going to completely transform it. And I think that's going to happen to the justice system, too. I think future generations, maybe not my grandkids, maybe later than that, they're going to look back on the human-powered era of justice and think, that was not justice. There was so much bias, there was so much unfairness, there was so much randomness that was baked into that process. Just like they trust the algorithms to drive their cars, they're going to trust the algorithms to make decisions. And it's not going to be the same thing as going to a judge in a wood panel courtroom, with the robes up on the podium. There's a lot of interesting signaling going on there, right? And all this litigation romanticism and all these TV shows and everything about justice will be done, and we've got to get. There's going to be a cleanliness to a certain extent to the algorithm, and it's going to take time to get there, and the algorithm's going to have to iterate over time. I believe there's going to be a time when someone is going to get a divorce, and they're going to go and communicate with their spouse, and they're going to upload all their documents and their pensions and their bank statements, and the algorithm's going to process it all and say, this is what I think a fair divorce is for the 2 of you. And they can adjust it. Who's going to get the vacation, who's going to get summer, who's going to get
certainly
winter.
sounds better than a lot of the divorces I hear.
But the point is, even in California, we have an Excel spreadsheet you can download from the State Justice Council, and you put in tuition and healthcare costs, and it runs calculation and says, we think fair spousal support is this and fair child support is that. There's no AI behind it. Just some bureaucrat sat down and they put together this spreadsheet. But we can do a lot better than that. And in that future generation, those people are going to trust that algorithm to give them a good recommendation, especially if they can request a human review of the algorithmic recommendation easily, and if they can make adjustments to it by mutual agreement. And I think that is a vision of the future here. I don't think that it's, like I said, we're not going to have digital judges. It's just we're going to trust algorithms in so many areas of our lives because objectively we're going to see that the results they generate are better than the alternative.
I want to push you on that a little bit because I think first of all that you can correct me if I'm mistaken. I think that in her research she showed that in arbitration people didn't want the machine to decide.
That's right.
They wanted it for mediation when it wasn't obligatory. So I think that we have to maybe be a little bit careful when we make the comparison between automated cars or autonomous cars, by which people will say it's not, there's no human element within it in the sense of compassion, because I think that's part of the deal with the judiciary or other aspects of life, whereas some people might prefer not to have computers in some areas maybe, and they would say, no, this I don't care even if it's statistically better for me to use that machine in that area, I want to have the human element in it, or to only have it. So
I agree with that.
I think that there might be a little bit of differentiation within those different types of areas, so I'm not sure how it will apply to different types of ODR, but...
Well, I think that also is relevant to the third party and the fourth party. That it's not like we're going to get rid of the third parties and replace them with fourth parties. It's just, if parties come in and the first thing they do is interact with an algorithm and it makes a recommendation, and then they sit down with a human, and that's where they talk about, hey, when you did this, it hurt me and this upset me, and you have to do an apology. That's not going to be kicked out by a machine learning algorithm. That may be something that a human needs to do, but maybe by putting a lot of the number crunching into an algorithm, we can make the humans do what the humans do best, and not waste their time on a lot of the stuff that the fourth party can handle. Maybe a little bit more quickly, more efficiently, and in a more trustworthy fashion.
I think it's part of the larger discussion of the industrial 4.0, like where are we going? I think in the industry it's rather clear that we will use more autonomous vehicles or machines to do the things that we don't really need the human element. But the bigger question will be the lawyers, the psychologists, the actors.
Sure.
I mean, so just maybe.
I think it's an excellent point. Orna, do you want to say?
We were just talking about that a few days ago, about the sort of death of procedure. So it seems like the big challenge is really to think about these new metrics and sort of criteria for evaluating the processes, even if we don't want to talk about justice, but we want to talk about fairness or consistency. So up until now, we've used, I think, the dual measure, right? I think we've looked at similar cases to the extent we can glean what a similar case is, going through a process in which we hear the parties in different ways. There are different ways to hear them, but they do get an opportunity to tell their story and then reach an outcome. And typically we would add a layer where we want to see that the outcomes are not only consistent, but are not biased against specific groups, right? So that would be, I think, a way to kind of, and now we're cutting off the procedure part. We're staying with the outcome, and the, I mean, not now, this is still not here, but I think that is a challenge we kind of want to bear in mind and think, and maybe we're going back to the dispute system design phase, and maybe we're saying, okay, the quality control and the metrics come in there, and that's an ongoing process. How we design these processes to work, but I think in general, when we think about these questions of fairness and justice, I mean, one thing ODR has done is really lower barriers for low-scale, low-value disputes, which, I mean, we've become accustomed to a justice system that is inaccessible for certain types of problems, and we've accepted the system as such and haven't really questioned it. And another thing it has enabled us to do is to really rethink the way our processes have been structured, and then sort of in different areas think about maybe how we can better structure them, use new tools, and then this new phase raises a whole set of different questions.
Well, I think that one of the things that I find in working with the courts is sometimes judges and lawyers, they talk as if the civil code was brought down, from the mountain by Moses, like it cannot be altered, it is written in stone. And it's like, wow, there's a lot of, some of these things are relatively recent innovations. So what I constantly am telling courts is don't use technology to pave the cow paths. The system it's not immutable. We can use technology to make the existing system marginally more efficient. But these technologies give us opportunities to rethink. You have to have technological development happening at the same time as legal process evolution. And there may be steps that we had in the old process that we don't need anymore. But if we say the legal process operates the way it operates and we just apply technology against it, then we may be enshrining inefficiencies that are unnecessary in the system that we could do better if we were to think from a clean sheet of paper. The Civil Resolution Tribunal in British Columbia is an all-online court. There is no face-to-face. and they go all the way through hearing. And it's a pretty radical rethinking of the way that a court can operate. But the metrics are amazing. You know, one of the things we have in the United States is a huge problem with default judgments, especially in debt collection cases, where you know, a business says, hey, you owe us this money, and they take you to small claims court, and 85% of the time the party doesn't show up to defend themselves. So the court gives a default judgment, and then the company has the ability to go garner the wages of that debtor. Well, if you do it online, we see those default judgments drop to 15%. So it's like a lot of the assumptions about the way the process operates presume face-to-face interaction. So we need to think very creatively. And I think legal education, too, is very backward-looking. It's very precedent-based. If you go to business school, they say, okay, here's double-entry accounting, here's marketing. Go invent the future. We don't know what the future looks like. But we don't educate lawyers that way. We say, this is the way the system operates, and have you learned your precedent? But we need to give them tools and say, go invent the future. It needs to be much more entrepreneurial, much more future-oriented, so that we don't just enshrine existing processes. So I think that's very much along the lines of what you're saying. Did you have a comment?
Yeah, I just was, I agree with your suggestion that the proper point of comparison is not courts and the justice and the way we idealize, at least in the United States, certainly, because as you point out, like, 1 or 2% of the cases actually go to trial. So it's not just low value cases, these are very high value cases.
Yeah.
And why don't they go to trial? Because the parties know that if it's a jury trial, who knows what the jury is going to rule in. And any judge worth his or herself is going to make each side think that the decision is going to be completely arbitrary, right?
Well, judges put a lot of pressure on people to settle.
That's what judges do. They
Yeah,
purposely make the parties feel like, you know, it's a complete crapshoot. You better settle, right?
Totally.
So what judges do is manage settlement.
Yeah.
So that's the point of comparison. Is like, are you managing settlement more efficiently than judges are managing settlement? I think for most, 98% of the cases.
And I think there's a strong argument that we do better than that process, that kind of bloodletting process where it's like, who is willing to pay more money to keep this case going, which is often what these civil cases come down to. Again, as a non-lawyer mediator, all my work has been on the civil side. But the interesting thing about working with Tyler is I now have criminal judges coming to me and saying, we want to utilize your tools. I'm like, I'm a little nervous about that. We're talking about life and death. They said, look, what you have to realize is the vast majority of those cases also come down to negotiations, where you have the prosecutor and